Welcome to the Stratford IP Strategy Academy. In this session, we will explain the process you will need to follow in order to file for and obtain a patent, and what to expect from the Patent Office. Let's get started. Registering a patent can be a complex and sometimes lengthy process. The typical phases of preparing a patent application are illustrated here. Let's dive into each step. The first step is, of course, the development of the invention itself. There are several different paths to the conception of an invention. It may come from a sudden burst of inspiration, an improvement upon an existing device, solving a problem, a mining session, a hackathon, or even a review of R&D grant submissions. You should have a simple invention disclosure process that is known by all of your employees. After a disclosure is submitted, a timely decision must be made about whether to file a patent application, catalog as a trade secret, or do a voluntary public disclosure. It is important to note that, before a patent is filed, care should be taken to avoid public disclosure and limit disclosures only under a non-disclosure agreement. Some countries have restrictions or deadlines relating to what can be filed after public disclosure, and you don't want to unintentionally lose rights. Now that you have made the decision to obtain patent protection for your invention, what's next? Although not a requirement, it's a good idea to perform a patentability search as your next step. This will allow you to check if someone else has already thought of this idea before you invest time and money in applying for a patent. After the patentability search, the inventors and the patent agent refine the invention to its fundamental, innovative concepts. This becomes the foundation of the claims for the patent draft. Once you have refined the fundamental concepts and have the basis for your claims, you are ready to begin drafting your patent. A patent application can be prepared in as little as 2 to 3 weeks, depending on the input and review process of the inventors. During the drafting stage, it is important to capture all variations and embodiments of your invention in the patent specification as well as related drawings. The patent agent will also include a set of claims that must be supported by the specification. This will determine the potential coverage of your patent. The priority date of your invention will be based on the content of the patent application as filed and will only cover the embodiments that were included. The priority date and coverage will have a huge impact on the value of your patent. Any additional content not disclosed in the initial filing will need to be filed as a separate invention and will not benefit from the earlier priority date. When the draft is complete and ready to file, the next question you need to ask is, where do you want to file? You should file in every jurisdiction that you wish to obtain protection. If the USA is a country of interest, you would typically file there first to start the examination process, giving you 12 months to decide where else to file. In order to secure a filing date, which will become the priority date of your patent application, your patent application must be filed with the appropriate fees, which depend on the size of your company as described in the patent offices where you file. Using the wrong entity size can lead to invalidation of the patent. It is key to name all inventors, including anyone who contributed with the development of the invention. Failure to do so can result in invalidation of a patent application or a granted patent. Similarly, it is also illegal to put names of inventors that have not contributed to the technical aspects of the invention. For example, those that were only involved in reviewing and editing the specification. Once the application is filed, it enters prosecution. This means the Patent Office will evaluate your invention to determine if it is patentable and what the scope of protection will be. The examiner will issue a report called an office action, allowing or rejecting claims based on patentability criteria. Typically, there will be 2 to 3 office actions, where the examiner and the patent agent go back and forth before the examiner is ready to allow the claims. The role of the patent agent is to get the broadest claims possible in light of the rejections raised by the examiner while trying to get the application allowed. Do not be surprised if the first office action rejects all claims. This is common. If an application is allowed at the first office action, it is generally an indication that the claims were overly narrow. In this case, care should be taken to file a much broader continuation before the patent issues. Once an office action is issued, you have 3 months to reply to the rejections. Filing of a response can be delayed for up to another 3 months, however, late fees will apply. If, after 6 months, no response is filed, the application will be deemed abandoned. At some point, if no agreement on the claims has been reached, you will need to file a request for continued examination in order to continue prosecution. In some cases, depending on the examiner, there can be more than 3 office actions. Should this happen, your patent agent may recommend applying for an appeal, where an appeal board will decide whether to allow the application or send it back to the examiner for further review. Another option may be to file a continuation and abandon this application to restart the prosecution phase, with hope of getting a different examiner. If the prior art uncovered by the examiner is too strong, your patent agent works with you to decide whether to abandon the application. It is important to understand that prosecution happens in parallel in each country you have filed your application. Depending on your patent agent and the complexity of the office action, you can expect the cost of answering an office action to fall anywhere between $3,000 and $10,000. There are some programs available to save on prosecution costs. Remember, this can be a complex process, but there are many options available to you on the road to getting your patent granted. The right IP team can help you navigate this. The process to patent an invention begins with development, where you identify and triage, moves to drafting, where you refine the scope of protection, then to filing the application, and finally shifts to prosecution, where you negotiate your IP rights coverage. Although complex, the right team will help guide you through this process. Filing a patent can be rewarding, and it will concretize your creativity while increasing the value of your company.